Hello, everyone. Welcome to this Business Advisory Services update on legal issues relative to research and development. Today, I'm joined by Matthew Karakalakis, the Principal Legal Officer of Amk Law. How are you today, Matthew?
I'm very well, Peter. It's always a pleasure speaking with you, so happy.
Yes. I'm looking forward to this because we've been running this series on research and development for the past 6 or 7 weeks. And we've touched on a lot of different components of research and development, but this is the first time we've looked at the legal issues. And obviously, people who are undertaking research and development are putting a lot of their time, their energy and money into developing a product. They need to make sure that they've got some ownership and protection of this new asset that they're developing, don't they?
Absolutely. There's a lot of time that goes into the innovation when creating new products, new technologies. And there's a lot of protections that need to be considered. Otherwise, people can find themselves in the position of spent a lot of hard hours working, researching, and developing something that's shiny and brand new, only to then be exploited. So it's critical that the right protections are in place.
Yeah, that's right. And Matthew, I know that you and a colleague have developed a product called Boost Legal Templates, which I understand is very handy for a inventor and a small business and Aboriginal and Islander people as well who are inventing new products or creating artwork. I imagine this whole area of protecting their legal rights. So do you just want to start off our conversation today by giving us an overview of the material that you and your colleagues have developed?
Absolutely. And I want to give everyone a brief understanding about Boost Legal Templates. Of course, you can always check out the website, which is just boostlegaltemplates.com.au, and you can discover more about what it is. But in this discussion today, Peter, I've got some slides that I want to share. It'll take us sort of a few minutes to go through them and give a bit of a deeper insight. But let's begin with this. Boost Legal Templates is a fantastic technology that has come out of the research and development. So it's actually a direct result of the topic that you've been speaking about.
Right.
The great thing with Boost is it gives those business owners the opportunity to have quality legal documents at only a real fraction of the cost. What I mean by that is businesses will need different agreements, service agreements, product supply agreements, contract agreements, and employment agreements, plus much more, and they're all on Boost Legal Templates. Normally, if you want to see myself or another top tier lawyer in preparing one of those documents, it might be something in the vicinity of $2,000 plus GST. Boost Legal Templates has all those kinds of documents available now for only about $180 and all less than $200, including GST, which is only a real fraction of the cost. And creating the documents is easy because there's online questions. You just sort of jump online, go through the questionnaire, fill out the details, and then in less than 5 minutes, the document itself will be in your inbox. So there's no need to go and visit lawyers, pay parking, no need to wait for the couple of weeks turnaround and things like that before the agreement's there. Boost Legal Templates has it there for you almost instantly, which is another great benefit. And something perhaps we're proud of most with Boost Legal Templates is the community impact that we're looking to achieve, because proceeds from every single sale go directly into helping computer youth literacy rates for Aboriginal community in Northern Territory.
Oh, okay, great, yeah.
Community impact that we're really looking to achieve and inviting people to be a part of through the Boost Legal Templates website and the products we have. I would love to be able to share a short presentation, if that's okay, and that's only because the presentation that I have does give some insight into some of the legal components And then it also gives an understanding about different types of legal documents. So I'm just wondering, at the moment, the slideshow that you can see, or the screen you can see you see the slide clearly from your end now, Peter?
Yes, I got Boost Legal templates on the screen.
Okay, so it's all clear from your end?
Yes.
Okay, fantastic.
Oh, you just need to hit the slideshow though to have it, and then hit the play from,
Slideshow.
double click that and hit play from start.
Okay, great.
And now you've got your template taking the full screen, so you're away.
Yep. And then, okay, fantastic. Thanks for that. I can see you've had a few of these presentations by now. So
we've done hundreds in the last 18 months. And a few headaches along the way.
Yeah, so thanks for the IT tip then on this one, Peter. So when you've got documents that are out of date, they lose their legal effect. And so what that means is, as your business changes, as your business grows, through things like research and development, so should your legal documents. You've got to make sure you've got all the documents that you need and that they're all up to date. So Boost Legal Templates helps with precisely this as well. There's a variety of legal documents, and there's a tab that sets out all the different types of agreements. But one of the very popular agreements is the Shareholders Agreement. Yeah. See, a Shareholders Agreement really is important when you've got a company structure in place. And because of the liability benefits of companies, Shareholders Agreements are very commonly needed. What a Shareholders Agreement does is it sets out how a company is to operate, sets out things like the roles of directors, the rights of shareholders, governs how important business decisions are made, how capital requirements can be met, not only now but in the future as well. And also a Shareholders Agreement can set out provisions about incoming investors, outgoing investors. All other crucial matters are made clear through a well-written Shareholders Agreement. Sometimes when going through the Shareholders Agreement process, it's about understanding what you don't know. You know, there's sort of the hierarchy of the questioning is sort of like you don't know what you don't know, then you start knowing what you don't know, then you get to the point of knowing what you know and it's all clear. The questionnaire process that's operating through Boost Legal Templates does precisely that. It takes people from the position of not even understanding what needs to be in these kinds of agreements to ending up with a clear understanding through the questions that are asked and having all the provisions set out in the agreement. So if you look at a Shareholders Agreement, we've got questions about the equity stakeholders, voting rights, appointments of directors, the business decisions and how they're made, selling shares and processes about capital, and also dispute resolution to avoid any sort of nasty argument between directors and shareholders. We've got here the most important contract you'll ever sign. One of our team members wrote this and put the box around it, and I probably would agree with that. It's a vitally important contract, especially if you're operating a company structure.
Yes, yes.
I saw, Peter, you had a really good newsletter that you circulated to your subscribers list that spoke about the corporate trustee. And that was a very good bit of information you had there. Remember also, corporate trustees should have their Shareholders Agreement. So what you need to understand as well is the housekeeping and the cleaning up of things also takes place through getting your Shareholders Agreement accurately written. The Shareholders Agreement can set out some administrative requirements like ASIC filings, company records, plus much more. Sometimes people even go through the questionnaire process just to understand the issues that go into it. So you don't even necessarily need to go ahead and buy the agreement now, but what you can do is just have a look at the questionnaire and go through those questions because it turns your mind to the important issues. You know what I mean?
Yeah.
Now, another excellent document available on Boost Legal Templates, or Boost for short, is the employee handbook. And see, what an employee handbook does is it sets out the obligations and helps managers and businesses make proper decisions for the right culture and fairness to take place in an organisation. Most people know that employees and managing employees and having the right team culture can be the most challenging part of a business. And there might be some people watching this video, because I understand it's live, but also on the social media and that, like things are done these days. There'll be people that have got some small businesses, but also some of those larger businesses. The thing is, as businesses grow, having things right with the employees become even more important. And the employee handbook is really, really useful for those reasons. Now, there's also employment contracts. See, the employee contract sets out more strongly the actual legal requirements that employees need to comply with. And there's a whole range of legal obligations. But when you look at the research and development side of things, confidentiality provisions, making sure that the property, the intellectual property and processes, business information is all kept confidential. That's a key component and key obligation that you need to make sure your employees are complying with when you've got a research and development focus within your business.
So, Matthew, does that mean that if a company's undertaking an R&D project, they really need to check what they've already got to make sure it's going to be wide enough to cover the R&D activities?
Absolutely. You need to make sure that what you've got in your employment contracts do absolutely cover the confidentiality requirements that you have of your employees, as well as the intellectual property components, to make sure that the intellectual property created through the research and development remains yours through your business structure. And these are some of the provisions that are set out in the Boost Legal Templates employment contract. And see, the other thing to remember is this, Peter. When you're in the startup phase of a business or you're a small business, sometimes you need to beg and borrow to be able to get in place your documents, because as I was saying before, legal costs can be expensive sometimes. Now, because of the cost effectiveness through Boost Legal Templates, it just makes sense that if you have any concerns about the confidential information provisions or any of the requirements of your employees, that you get the new legal document through Boost Legal Templates, because that's even more cost effective than having your current agreement reviewed by a lawyer. So if you want to make sure it's all right, and even if you're not sure whether what you've got in your agreements does what you need, Boost Legal Templates is probably a good way to go. Yeah,
and Matthew, we were talking before we went on air, the situation where an employee in their employment agreement, and that person might have been employed 3 years ago, and it described her job or his job in a particular way. Maybe the person was described as being a receptionist. If they got involved in the research and development project, should an updated employment agreement be prepared for them?
Absolutely, because you need to make sure that the employment agreement not only covers the employee for when they started, but you also need to make sure that the employment agreement covers their position and their role as it's changed. Because it's normal, right, for people to come into an organisation, they start off in one position, they might start off as a clerk or graduate or whatever sort of starting role is. And then the longer they're in an organisation, the more they learn, the more valuable they are, but also the more intellectual property and confidential information they get access to.
Yeah.
So you need to make sure that the employment agreement itself properly and fully covers you for all those employee risks.
Do enough employers understand this, that it's not a matter of having an employment agreement signed, say, 4 or 5 years ago and then forgetting about it forever, that they need to be revisiting it every so often to see what the classification of that person now is?
Peter, I think that's a really good question. And I think that the legal databases that show the number of cases that end up before the Federal Circuit Court as a result of employers not fully understanding their contractual arrangements with employees probably indicates that there isn't enough employees that actually know what needs to be covered. What would also be really interesting is if anyone is an employer and is watching this video, it'd be great to see their comments and sort of get a feel in the comments section to this video about what people think and what the experiences have been in terms of employers and, understanding about employment contracts. It'd be great to see that sort of firsthand, through the online video post as well.
Okay, and I imagine that this, if an updated agreement needs to be prepared, this should be prepared as soon as that employee starts becoming part of the R&D process, not in 18 months' time when the project's finished. Is that right?
Absolutely, because when the project's finished, the intellectual property has already been created, and that's where you've got that massive risk of it becoming the property of the employees. Now, a golden motto for employment contracts is this: you need to have a new employment contract in place as soon as anything changes in that employee's role or position.
Okay. Well, so, that's an interesting area. And in fact, in our new research and development product package we've produced, we already had some notes around this, but I think I'm going to toughen them up a bit and put a bit more information in there, because it's one of the many decisions that an employer needs to be making when they start planning a research and development project. There's things to do with the project itself so they can claim the research and development incentive rebate from the tax office and Oz Industry, but there's all these other peripheral activities they've got to think about, isn't there?
Absolutely. And I think the level of information that you put out there, Peter, that I've seen has been excellent. So toughening things up and doing things right is really important. How about this quote we've got here? I'd rather shake hands with an honest person than sign a contract with a crook. So I think that goes down to toughening things up, but also making sure you've got the right infrastructure and right people in place, and then making sure that you've got clear provisions in that contract to cover things like confidentiality and making sure that the information that's sensitive to the business, as well as the intellectual property that's of great value, remains yours within that business structure.
Okay.
Also on Boost Legal Templates, we've got website terms of use. So when you talk about research and development, it's very likely that people are setting up new websites for products and businesses that have evolved from that development that's taken place. And see, every business does need to have a website these days. And so every business also does need the website terms of use, because the website terms of use set out the requirements for when people are using your actual website, making sure they don't do anything wrong, making sure they don't actually reproduce the content from your website, having disclaimers and limitations of liability to protect you. You can even think about, when there's a lot of places these days. I was speaking with my wife this morning. We took our puppy to the puppy day school.
Oh, yeah.
And they get you to sign this limitation of liability form. If your pup bites anyone or your pup's bitten, bad luck, limitation of liability. Those sort of things are very common, right? A lot of those places, they're sort of set out that there's a lot of businesses that what they say is if you go into their shop or if you use any of their services that you can't sue them. Well, there's been a lot of cases where people have gone onto a website, relied on something in the way that they shouldn't have relied upon it, and then tried to sue. What another great thing the website terms of use does is just like that puppy example. It says that if you want to come into our website, you actually have to follow these rules, and we're not going to be liable if you misunderstand anything that's on our site, which I think is very, very useful for people to know.
Yeah.
The website is almost like a shop, right? And in some instances for online sort of those product businesses that sell things online is in fact a shop. The other thing is that privacy policies are important. Privacy policies must be on certain websites where they're required under the Privacy Act. So there's some turnover thresholds, as well as some other requirements. But even from a perspective of data collection and information point of view, as we do live in the data era, a privacy policy really does need to be on your website. So these are great documents to have. And remember, these are also available on Boost Legal templates.
All right. Okay.
To get some more information, if you're an Australian small business with some legal needs, remember it's more than just a template, it's the legal boost you need. I wonder what you think of that, about that saying, but hopefully it's a good motto because that's what we try to achieve. We try to achieve the legal boost for businesses through the Boost Legal templates. And you can check out the website, boostlegaltemplates.com.au for some more information.
Okay. Thank you. That was very interesting on that point of view. Thanks, Matthew. Okay, so we've discussed that part of things, but if we've got some small inventors or even small companies out there who are starting a research and development project, it's not unusual that they can then get involved with others. It might be a businessman who wants to put some money into it or offers to put some money in to help. It might be a university that they get involved with or a research centre. I was looking at the documentation of a new client that I've got in my consulting business yesterday, and they had 2 or 3 universities and research organisations involved. They had certain documentation there, but does everyone do that? Or does the inventor tend to just keep on going with input from others without thinking about his or her legal position? Sorry,
Peter, I'm not fully clear on the question.
Well, I'm really getting at what advice should anyone, I suppose, and I'm thinking more of a small one-man or one-woman inventor that's invented something, and they're trying to get input from others who are going to introduce knowledge and perhaps some money. Should there be protection in an agreement for everyone? Do you think people do that early enough, or do they forget it and then they get caught up in a legal dispute later on?
I understand. That is an excellent question. The answer, I think, to that, Peter, is that people often leave getting their contracts in place way too late.
Yeah.
And so I think part of that reason is people not understanding what sort of agreement they need to have from the very start. One way of finding that out could even be going through Boost Legal templates. We have a tablet that says the documents that are available. And so you could even use that as a way of familiarising yourself with the type of legal documents that a business does need.
Yeah.
Too often what businesses do is they leave themselves in a position of having some emails and communications and then forming an arrangement, going ahead with some sort of business idea, and then often those business ideas and their relationships can sour, and then a big legal dispute comes up and they're left trying to point at discussions and emails and things like that. That's a really, really hard way to prove your legal position if you've been taken advantage of. The best thing to do really is having a contract from the very beginning. And sometimes for research and development businesses, that can be hard because a lot of cost goes into the research, into the development. And often when you've got that product in place, it can sometimes be a little bit of time before you actually start getting returns on that.
Yeah.
In those situations, that's another reason why the affordability of Boost is a real advantage. But the point there too, Peter, is just like they say, an apple a day keeps the doctor away. Getting the right legal documents right up front can keep the litigation away. So it's
unfortunately, some of these people who are doing this initial core research really haven't got much money, and they're lining up what they're going to pay out. And unfortunately, I think they look at legal bills as being an expense that they think they can't afford, but they probably regret that later on if they get involved in a legal dispute.
Absolutely. It's just like the people who say they don't have enough time to take care of their health and fitness, and then they can get sick and they end up going to hospital or something and spending months in recovery.
Yeah.
Unfortunately, if they're in that situation, they do find the time. Whereas health and fitness can be something that's really fun and enjoyable, done right from the start. I think you can even look at legal matters like that as well. If you've got your contracts written properly from the very, very beginning, you can avoid the heartache and the massive cost that's involved with a legal dispute.
Yes, because a lot of work can go on. Let's look at a couple of other things. What's the process in making a decision as to whether a company should be talking to a patent attorney about registering a patent? Does that involve you as a legal practitioner if someone's talking to you about patents?
Patents can be a very complex process, and generally what we do is refer the patenting to the patent attorney. There's big offices that are set up as patent attorneys, and they often need to engage experts to meet the requirements of IP Australia. There's also, though, remember, branding and trademarks that are very important. So we directly register trademarks and take care of those sort of legal rights when they come down to trademarks themselves.
And at what stage of the process should the company or the inventor be conscious of things like registering a trademark?
The answer on that is as soon as possible. So depending on the number of classes and the trademark that's involved, trademarks can be anywhere from $2,000 and sometimes much more. But what you need to look at is what's the value of that branding to you and your business. Take an example like McDonald's. How much do you think the McDonald's brand is worth? There was a case recently where Hungry Jacks were making a Big Jack or something.
Yeah, I remember reading something about that in the Financial Review, I think. Yeah. Exactly.
And so McDonald's obviously took issue to that. So you think about it for your own business that's research and development based. How important is your own branding? How important is that to you? Is it worth $2,000 to protect? You might have just heard a dog in the background there. I've got 2 Rottweilers and I'm working at home today. So I reckon we've got some pretty good protection here. But yeah, you do need to look at things from the protection point of view as well, Peter.
Good point with your dogs barking in the background. I thought that was your puppy at first, but sounded a bit more mature than that. What about trade secrets? Do people who are inventing products decide they might get advice they can't go down the patent path or they can't afford that? It is an expensive proposition, isn't it? Are trade secrets a viable way for them to deal with, say, a manufacturer or distributor?
Best way of dealing with trade secrets is having properly written contracts. Another example of a properly written contract is a confidentiality agreement, or otherwise known as a non-disclosure agreement. And what that does is sets out the limited purpose in which some information is being shared. So it might be sharing some information with a factory so they can make the products that you've created. So you can have an agreement like a confidentiality agreement that sets out the basis in which it's all meant to stay confidential and not be disclosed for any reason other than producing the product that you've spent such a great amount of time and expense in producing and developing. The good news on that is Boost Legal Templates also does have the non-disclosure and confidentiality agreement right there on the website.
Oh, okay, right. Well, that's very good, Matthew. I think we've covered what I had on my list here, anyhow, and what you discussed as we went through Boost Legal Templates at the beginning. Is there any final comments you'd like to make to people who are involved in research and development? They should not ignore legal matters, should they?
Absolutely, they need to get their legal matters right. And the other thing to bear in mind with legal matters is sometimes by turning your mind to the issues, it can help you in being protected from them. So get the advice you need, do the research on legal issues as well, and really understanding that just like there's no shortcut when researching and developing a particular product, there's no shortcut with legal issues either. More often than not, if it's not done right, it can come back and bite you. So I think those new products need to be developed right so that the market can find proper traction with your products. And I think the same sense goes to legal documents. You just got to make sure they're done right.
Matthew, thank you very much for that. Now, where can accountants and business people who have been watching this video contact you? Yep,
so probably the best way, considering we've been speaking about research and development, is probably through the boostlegaltemplates.com.au website. I'm also, as you were saying at the introduction, the principal solicitor and director of Amk Law. You can look us up on the web as well. Amk Law is the name of our firm, and looking forward to speaking with anyone that we might be able to assist.
And Matthew, you're able to handle clients situated anywhere in Australia?
Absolutely. We won an award last year for innovation and technology throughout the legal profession. And one of the reasons for that is because of our online methods and processes that we have in place means that we can absolutely help and assist clients throughout the country.
Okay, that's great. Okay, well, Matthew, thank you very much for your comments today. And I would urge anyone who is watching this video, whether you're an accountant or a business operator, obviously the accountants, if you've got clients involved in research and development, please make sure they get appropriate legal advice. And if they're having difficulty finding a commercial lawyer that they can have a conversation with, I'd be happy to refer them on to you, Matthew, and hopefully they will do that so that these people can get the right advice.
Thanks again, Peter. Thank you very much for the opportunity of being a part of the fantastic webinars that you've been putting together. I always like catching up with you, and I hope you keep enjoying the great work that you do.
Okay, thanks, Matthew. Okay, everyone, thank you for being with us today. This is the end of our series on business advisory services. We will be having a break now for a couple of weeks, and then we will be, because we've got Easter and school holidays and everything else, and we'll be looking to resume a series of these regular conversations on matters to do with businesses in May. So thank you for having participated with us. So Matthew, once again, thank you very much. And we will catch up with you shortly.
Thank you very much, Peter.
Thank you, everyone. Goodbye.